He wouldn't listen to me and told me to rape me.
Come on, you. All right, let's be on the record in case number 2019 CR 811, captioned State of Kansas versus Billy Dupree. Would the parties announce their appearances, please?
Your Honor, may it please the court, Suzanne Valdez appears for the state as a special prosecutor.
It please the court, Your Honor. Mr. Dupree appears by video and with counsel Chris Scott.
All right. Mr. Dupree, as your attorney just mentioned, we are doing this by video conference due to the pandemic. My understanding is you had a chance to talk about that with Mr. Scott and that you don't have any objection to appearing by video and waiving your personal appearance in court today. Is that correct?
Yes, sir.
All right, thank you. So our first order of business today, I should note for the record, a brief history of this case. This case was tried to a jury back on March, first week of March of this year. The last one we got to before the pandemic struck. We originally set the sentencing for April 16th with a setting for the motion for new trial at the same time. Obviously that didn't happen, the courts were shut down, but since that time we have been able to schedule this for a motion for new trial and sentencing by video. So with that, Mr. Scott, I have reviewed your motion and Ms. Valdez's response, and I would give you first chance to argue that motion.
Yes, Judge, and we had requested a new trial in this case. With point one, and I'll just elaborate because you said you've already read the motion, but first point being that the court did not instruct the jury on a lesser included charge of theft for the robbery charge. As everybody's aware with this case, this is just a bizarre incident and set of facts, and what even led my client to even come into contact with Mr. Coles. And we ended up how we ended up, Judge. But there was a lot of gray area in this case. And the jury did find my client guilty of robbery, but we feel that if the court would have instructed them on a lesser included of theft, that they could have reasonably come to that conclusion as well. As it does appear that property was taken in this case, but you know, they never had the opportunity to decide between robbery and theft. I think they would have given it some decent consideration. I mean, you can tell by original count one. I mean, they went with the lesser included from kidnapping and convicted Mr. Dupree of criminal restraint. And I think they would have given legit thought to a theft charge if they were given that, but they were not given that charge or that lesser included offense, Judge. And because of that, I do believe that my client has a right to or should be granted a new trial because of that. As well, Judge, as in the court is aware, I had objected during the trial to Sergeant Joyce and her testimony that where she described this case as felonies and particularly violent felonies, Judge. And it wasn't in the context either of her saying, you know, what do you do? Well, I work in the violent felonies unit of the Wyandotte County Police Department, which I think that would actually be an issue too. But she kept bringing it up of, well, when we go out to the scene and we investigate felonies or violent felonies. And she kept saying it, Judge. And in fact, when I looked in my notes from the trial, and I listed in my motion that she proceeded to use the term felony 6 additional times. I mean, for whatever reason, she just wouldn't stop using it. I think that's unduly prejudicial to a person in that, you know, I don't want to just play the jurors off like they're stupid. I mean, when they hear kidnapping, robbery, they can probably assume that's a pretty serious offense, but we don't just sit there. I mean, there's a reason that, you know, they know what they're charged with, but we don't tell a jury, this is a level 1 person felony. This is a level 5 person felony. I mean, we don't tell them that. I mean, we don't inflame the passions of the jury by telling them, oh boy, you know, this is an off-grid felony if it was a murder case. We don't say that. They don't get to know about the penalty. You know, we even tell them, you know, a penalty in a case is not your concern, but we know that jurors are human. And they just, if they're repeatedly getting beat over the head with felony or violent felonies, you're getting beyond just listening to the facts of the case. And, you know, and they may be thinking, Mr. Dupree, oh boy, violent felony and violent felony. No, this guy did a really, really bad thing. And it's just not for them to decide, Judge. They're just there to listen to the, to the testimony in the case and judge the facts as they are. And, my objections were denied. And again, Sergeant Joyce was not ordered to refrain from saying that. And she just kept saying it, Judge. So between that and a lesser included not given to the jurors for the robbery, I think Mr. Dupree, I think both of those were unduly prejudicial. And I think, if they were given a lesser included or Sergeant Joyce was prevented from testifying about a felony, Judge, I think that the jury could have come to a different outcome in some of these matters. And I think because of that, Mr. Dupree should be granted a new trial as to count 2.
All right. Thank you, Mr. Scott. Ms. Valdez.
All right, Your Honor. Can you hear me?
Yes.
All right. So concerning this motion, Judge, the state did file a written response. I just want to point out with regard to the instruction or failure to instruct on the lesser included offense of theft, Mr. Dupree, intimidated, he threatened, he bullied the victim in this case, and there was lots of evidence to suggest that was what happened. In fact, the videos that were taken by Mr. Dupree on his own using the victim's phone that he took from him made those points very, very clear, and the jury did see that, and the evidence was clear that there was intimidation. Certainly there wasn't any sort of bodily contact, but certainly his intimidation, his bullying, his threatening, all of that is sufficient enough to convict of the charge that he was convicted of. By his own admission, when the first day after trial, and he did a jail call from the Wyandotte County Jail, he even admitted basically to the elements of this particular crime of robbery. So at one point he says that he was going to beat his ass, referring to the victim in that case. So the instruction on robbery was appropriate. The lesser included of theft, I don't think there's error for the court not doing that. Concerning Judge Joyce's testimony about or reference to felonies, the court did address that motion for a mistrial at the trial. We did a sidebar. What was clear, I believe, without having the transcript in front of me, but certainly having my notes, trial notes, was that there was reference to felonies as Sergeant Joyce was talking about her job responsibilities and how she goes about making sure that these crimes are investigated, so on and so forth. I'm not sure she used the term violent. Often she used the word felonies. Mr. Scott suggests that she kept referencing violent felonies. I don't think that's necessarily accurate. I think he is correct when he says that there was reference to felonies in this case. But again, 2 points I want to make. It was related to her testimony about the procedure in investigating the case. And moreover, the jury knew that this was a felony case and felony charges that they were going to be hearing testimony and evidence about. So it's not prejudicial to the defendant. Certainly, I don't believe, at least from my notes, that she ever indicated that Mr. Dupree had committed these crimes and therefore prejudicing him that way. It was just talking about felonies in a very, very sort of general and sort of procedural terms. So we ask the court to deny that motion.
All right. Mr. Scott, Mr. Dupree, do you need a few moments in a breakout room?
Yeah.
All right.
Yes, sir.
Be brief. Mr. Dupree, you're a very eloquent person.
Yes, sir.
But I need you to be brief.
I
Make
will.
your point with Mr. Scott. You guys can talk about it. And Mr. Scott, you have the ability to bring yourself back in once I send you to this room.
Is it me and you now?
No, hold on.
Okay, but,
All right. Okay. So we will just stand at ease until we see them return to us.
Excuse me just 1 second. I'll be right back.
Yep.
Okay, thank you. Forgot to give them my email in case they finish fixing my, or replacing my water heater. Here we go.
let's see, if he can't figure out how to come back, I can bring him back, I believe. It gives them a minute to leave their breakout room.
Mhm.
So my guess is, oh, there they go. They figured it out. All right.
All right.
So we're still on the record. We had a breakout room that I sent Mr. Scott and Mr. Dupree to so they could have a private conversation. Mr. Scott, other things you want to add to your arguments to this morning?
Yes, Judge. After speaking with Mr. Dupree, I mean, he does make a good point that, when it comes to those lesser included offenses, the case law does say that the court does have a duty to instruct, even if not requested, even if the evidence is weak. And obviously, as we all know, that did not happen in this case. And we do want to make that point as well, Judge, and as well as, the state's argument that Mr. Coles, or at least the description given was bullying or intimidating and those kind of things. But again, that can still fall back on just, a misdemeanor theft, a lesser included charge to be given to the jury. And, and again, even if the evidence is weak, the jury is supposed to get a lesser included option.
All right, thank you. All right. Well, look, as far as the lesser included goes, it's really a kind of a two-step test. The first one is it legally appropriate? And it was legally appropriate in this case, given in that theft is a lesser included offense of robbery. But once you get past that hurdle, then you have to figure out, is it factually appropriate given the facts of the case? In other words, is there some evidence that would support a finding that this was an unauthorized taking of property from Mr. Coles, but it wasn't by force or threat? And there simply was no evidence. And it wasn't the defendant's position during trial, during his testimony, that yes, I took money and property from Mr. Coles that he did not willingly give over. That would be a theft, but I didn't force him. I didn't threaten him. I just took it without his permission. There wasn't any kind of evidence, not even the defendant's own testimony, that would support a finding that it is factually appropriate to instruct on the lesser included of theft. Mr. Dupree's position during the case was that Mr. Coles willingly gave him the money, and it was in payment for the wife coming over to apparently commit an act of prostitution with Mr. Coles, for which she was not paid, and various other things. Mr. Cole's position was he was forced by Mr. Dupree through intimidation, threat, to hand over his money unwillingly. And in fact, there was video evidence exactly of that, of intimidations, threat being used upon the victim to get him to turn it over. So it wasn't appropriate to instruct on theft, because there's nothing presented in the evidence that a reasonable jury could have said this was an unauthorized taking, but it wasn't by force or threat. And it simply factually is not appropriate to have instructed on theft in this case. As far as the testimony of the sergeant who responded, I didn't find it prejudicial to the defendant at all. I don't think there was an attempt, and even if it wasn't an attempt, there wasn't even an inadvertent message to the jury of this is a violent criminal, this is a very serious offense. I don't believe that that was the officer's intent, nor do I think that was the message that was sent to the jury. She was simply describing why she did certain things and contexting it in the procedures required when they are notified of an alleged felony. Um, and I'm not sure that Mr. Dupree and counsel can have it both ways, that this jury was somehow sophisticated enough to know that a felony makes this a more serious offense and Mr. Dupree more likely to be guilty or more dangerous to be set out on the streets. But then again, naive enough to not know that kidnapping and robbery, which were the charges against him, were not serious crimes. So if felony meant anything to them, and it's questionable whether it's not, it just kind of appropriately would describe the nature of the charges. I don't think there was anything prejudicial to Mr. Dupree. The fact that the officer testified as to what they were doing because they were called out to a felony call. And that procedure is different than, say, a person in distress call or a reported misdemeanor call or something like that. So I don't think either of those bases are grounds for new trial. Not only do I not think that they are error, but if they were error at all, there's no way that they had any effect on the jury and the ultimate decision that they made. And frankly, I think the jury demonstrated in the time they took to deliberate and the fact that they did give full consideration to the lesser included of the kidnapping, as evidenced by the fact is that they found him guilty of, that they carefully followed the instructions, that they weren't swayed by improper considerations. So for those reasons, I am going to deny the motion for new trial. And we are free to proceed with sentencing today. So having given some of my pre-determination of the or statement of the case, we'll kind of move forward with this. The guilty verdict did come down on March 5th, and that was to the first count of robbery, which is a severity level 5 person felony, a count 2 of possession of methamphetamine, which is a severity level 5 non-person drug felony, and criminal restraint, which is a severity level A misdemeanor. I accepted the jury's verdict. We've now held our motion for new trial and we are in a stance ready for sentencing. I've received the amended pre-sentence investigation. And the critical findings are as follows. As I said, the primary count of conviction is one of robbery, a severity level 5 person felony. The defendant's criminal history score was found to be that of A. That would leave him with a presumptive prison sentence with a presumed range of 122, 130, or 136 months. If he has to do that time, he'll be eligible to up to 15% good time credit and subject to 36 months of post-release supervision. If he were granted probation today, it would be for a period of 24 months to community corrections. As to count 2, that is a severity level 5 drug felony. For scoring purposes, the defendant's criminal history score is considered to be that of I. That would again leave him with a presumptive prison sentence, given the controlling sentence, with a presumed range of 10, 11, or 12 months. The same 15% good time credit, 36 months of post-release supervision, and 24 months of probation if granted. Count 3, the final count, as I said, is a severity level A person misdemeanor. I'm sorry, it's listed as a non-person misdemeanor here. It is a person misdemeanor. There is no presumption of prison one way or another. The presumed sentence is up to 12 months in county jail for that charge. Miss Valdez, I will ask you first. Did you have an opportunity to review the pre-sentence investigation? Do you have any additions, corrections, or objections to the findings thereof?
So, Your Honor, I did when it was first sent, and I, just for the court to know, I had mistakenly put this hearing on my calendar for Thursday, and it was when I was going to prepare for Thursday today that I realized the hearing was in about 20 minutes. So I went ahead, I didn't have a chance to review it one more time, but I believe that it includes everything that the court has talked about, if that's what the court is asking.
Mr. Scott, same question.
Judge, Mr. Dupree has not seen the amended PSI, but he and I have always operated off of that he was going to be a comeback as a criminal history A. And so there is nothing about his criminal history that we object to, and nor is a surprise.
All right. Mr. Dupree, is that correct?
Yeah, now the first charge of robbery is presumptive prison, right?
Correct.
So that means I can't get probation for that. I got to go to prison.
Well, it doesn't, no, the presumption is of prison. For me to not give you prison, I would have to find substantial and compelling reasons to depart from that presumption and grant you probation. Mr. Scott, I believe you filed a motion for a downward departure, did you not?
Yes, Judge.
Okay, so Mr. Scott is going to be able to argue for you that I should give you a lesser amount of time than is presumed, and also to grant probation, even though the presumption is of prison.
Yes, sir.
And then, of course, at the end of that, I'm going to ask Ms. Valdez to tell me her side of it. And then the last person I'm going to ask is you.
Yes, sir.
And you get a chance to tell me anything that you want me to consider in deciding what your sentence should be. Mr. Scott, I don't have it pulled up. I did read it. Did you file for both a durational and a dispositional departure? Or
I filed for downward durational, Judge.
all right. So, Mr. Dupree, your lawyer has filed for a downward durational. In other words, asking me not to give you as much time in prison as is required. I suppose he could argue for a dispositional. My guess is that he did not include such a request because he did not think that there was any reasonable way that that was going to be granted.
Yes, sir.
So, other question?
No, I just like to I guess say something on after they get done, and then you can ask Miss Valdez how she feels about what I said, and see how she feels.
Well, look, you get the last word, man. You are the one getting sentenced. You're going to be the last one I hear from. Okay.
Well, this is what I know. I know that the prosecutor has a big decision on what you're going to do, and I want her to also hear what I have to say, so she can kind of, because I know she's the state and she's the prosecutor, and so she has a big decision on what the judge has to do, just as well as my lawyer, but the prosecutor more of. And so I kind of want her to hear me, because I haven't, talked to her either. And I kind of want her to hear what I got to say, so she can say, well, Judge, yeah, well, I, feel this way. And so.
Okay. All right. I will ask her if she wishes to respond when you are done with your statement.
Yes, sir.
With that, Mr. Scott, I will hear your argument for your downward durational departure and any other comments upon sentencing that you wish to make.
Yes, Judge. And as you mentioned, we would love it if the court would consider probation. Obviously, when I'm figuring out what I'm going to include by motion, we have to be realistic as well. And, or at least I have to be realistic as well. I don't think I'm doing my clients any favor by coming at the court with something that's unrealistic, but just going all in on that, Judge. And that's why I crafted a motion for a durational departure. Obviously, Mr. Dupree is looking at a significant amount of prison time. and in particular, if the court would run everything consecutive, Judge. And I know he has a standard presumptive sentence on the robbery of 130 months in the Department of Corrections. And my rationale for filing for departure was that I think the court could find that the harm in this case is less than typical. Obviously, he was not charged with aggravated robbery. He was charged with robbery. There are no allegations that he tried to use a weapon or caused any bodily harm to Mr. Coles in the commission of the robbery. But the court knows the facts of this case. And again, as I stated earlier, just the bizarre string of events that this case was, and that Mr. Coles was trying to buy sex from Mr. Dupree's wife, and he ended up going over there. But Judge, this was, Mr. Coles was not a random victim that Mr. Dupree came across on the street. He showed up at his house because he was mad because of the situation with his wife. I think Mr. Dupree would even tell you he was actually more upset with his wife than he was with Mr. Coles, and that came out in the evidence. I mean, Mr. Dupree stated both in the police, it was noted in the police reports and their testimony, as well as his own testimony, of he had no plan to harm Mr. Coles or to take anything from him, and he was going to give everything back. And in the end, Mr. Coles did get everything back, Judge. And so that's why I put that I think this is, the harm in this case is less than typical. No cases are the same. And, 130 months would be a pretty harsh sentence on this case. I proposed 60 months in my motion and even 5 years. I think that would satisfy justice. I think that would be some pretty significant punishment for Mr. Dupree to go do 5 years in the Department of Corrections. And I think that would prove a point to him and show that, you can't act this way. You can't do these kind of things. But then after 5 years, and be less than 5 years with his time served, he'd be back. He'd be on post release. So the Department of Corrections would still have a thumb on him for 36 months. Again, I think all ends of justice could be satisfied with a duration of departure to 60 months in this case, Judge. I think the court can find substantial and compelling reasons exist and grant that motion. Judge, you want me to go ahead and do my entire recommendation, or you just want me to comment on the motion?
Yes, please go right ahead.
Judge, about the only other thing I have that is, as for the other two counts of the possession of methamphetamine and the criminal restraint, no matter what the court does as to the robbery, I would ask that the other two counts run concurrent with the controlling count in this case of the robbery, Judge. I don't think we're just splitting hairs at this point if we're running them consecutive and we're getting into the whole area of what is enough punishment, Judge. And no matter what, he's going to have significant punishment in this case for what happened. And I would ask that those two counts run concurrent. And as should be noted, and Mr. Dupree is aware of this, that even though it is a misdemeanor on the criminal restraint, there is registration involved with that.
Right. All right. Ms. Valdez.
So, Your Honor, I submitted a written response on behalf of the state. I just want to add a few things. First of all, I did not get a hold of the victim to be here today for him to voice what he thought would be just and fair. I can say that in prosecuting this case, I worked with the victim as well as other witnesses, law enforcement, et cetera, to try to handle this case in a just way. So I believe that whatever the court decides, the victim will be satisfied with. I just wanted to make that clear. In light of the defendant's criminal history, and certainly the case itself and how all of this unfolded and the facts in this case, I don't think the state does oppose probation. It's just not realistic in light of the defendant's history and what I've already mentioned to you. So I asked the court to deny that and not consider probation as a sentence in this case. So I do agree that the harm that occurred is sort of less than typical, of whatever that means. But I do want to make a point that if I believe that the case was properly charged, if Mr. Dupree had a weapon, he would have been charged with ag robbery, and the aggravated factor there. So just because, robbery was properly charged, as was kidnapping and the possession of meth. I do want to say to the court that I believe the jury verdict was just. I believe that the verdict was that the jury engaged in the trial and really found a just verdict. Ultimately, though, I do believe that the defendant convicted himself by a lot of the videoing of the events of that night, which, by the way, were hours for the victim to be tormented by the defendant. But the defendant took these videos were used as evidence. The defendant made admissions about his conduct and how he was essentially terrorizing the victim. So while the facts are bizarre, it is clear that the defendant was engaged in tormenting the victim for his own gain, whether it was to get money for his wife, on behalf of his wife, or because he was upset with his wife. I don't think it really matters. I do believe that as a prosecutor, we need to have the state needs to have a just punishment for the defendant. And so at this point, I would ask the court to leave it to the court's discretion to impose that sentence. And however the court believes is fair and just in light of the evidence, the verdict, and the defendant's criminal history.
Mr. Dupree, as we talked about beforehand, now is your opportunity to tell me anything that you want me to know in mitigation of your sentence today.
Okay, first of all, y'all, I want you to know that I did do 8.5 years in prison, got out, finished my probation, or finished my parole, didn't catch any charges. I got married, had 4 kids with a woman that had 1. Okay, and so we had 5 kids. You guys all know who my family is. I'm not throwing that up in the mix, but you know who my family is. I was a church guy. I was going to church regularly. I had my issues. Don't get me wrong. With this situation, Your Honor, if you look at the police reports, the victim in the beginning said I didn't threaten him. He said he was intimidated. He said my body language. Okay, he said my demeanor. Your Honor, I can be honest. I did intimidate him. I didn't intimidate him with threats. It wasn't hard to give me the money. I did tell him, hey, just like it said in the police reports, Your Honor, and I'm pretty sure you got the police reports. I told him I was going to call the police on him and have charges pressed against him if he didn't help me. I did tell him that. I did also tell him who my uncle was. I told him, hey, my uncle such and such, and I'm gonna have charges pressed against you. The video, Susan Valadez said the video was to torment. Your Honor, when I think of torment, I think of a real psychotic person being tormented by the devil to do devilish, nasty things to a kid or a person. Okay, that wasn't the goal with me and Mr. Coles. If you looked at the video, which you did, and my lawyer edited the video, but most of the video I was talking to Mr. Coles like he was my friend. I was confident in Mr. Coles. I was telling him I wasn't mad at him. A person that torments somebody, Your Honor, is not going to tell him I'm not mad at you. I constantly told him I wasn't mad at him. Did I extort him? Yes, Your Honor. Did I say I was going to beat his ass? Your Honor, you heard it, okay? But it wasn't, I'm going to beat your ass if you don't give me your money. I'm going to beat your ass if you don't give me your car. I'm going to beat your ass if you don't give me your phone. Your Honor, let me tell you, the police said in court that Mr. Dupree said he was coming and returning Mr. Cole's stuff. Your Honor, the case is done, okay? But what type of robber, comes back and brings back the stuff that he robbed, okay? Your Honor, I brought his car and I brought his phone back. I had his cash on me, but before we went to the ATM, Your Honor, the victim said that I didn't threaten him before the ATM. He said that I threatened him after the ATM, and I told you, he said he didn't even know what I said. But he said I didn't threaten him. In the car to get he said he wanted to get away from me because he was intimidated and he felt like giving me his car was the reason, was a way for him to get away from me. Your Honor, in the case, the cops got the keys to my wife's truck. I left my wife's truck. I also wanted to tell the trial courts, but I didn't get the chance to. Me and my wife was going through a hardship at the time, Your Honor. We was actually living out that truck. Okay, all of our property, all of our kids' belongings, like I told you, we had 5 kids. And so all of our kids' belongings, all of our medical cards and birth certificates and food and everything was in the truck. Okay, and I left the keys as collateral with Mr. Coles. So he had what is it? So he had something to say that he's gonna come back with my car. I didn't leave him taking his car with him, thinking like, is he gonna bring my car back? I left him with collateral, like, I'm gonna bring your car back, man. I'm not gonna steal your car. Christopher Scott asked, in fact, he said he was gonna give you your car back, didn't he? Yes. In fact, he told you that you was his friend. Yes. I told him he was my friend. I kind of compelled him to do that, Your Honor. It was an extortion. Okay, Your Honor, I wasn't gonna harm that boy. You seen him. Now you could probably be like, well, I don't know if he was gonna harm him. Your Honor, I'm a guy that don't prey on the weak. Okay, and so this is what I ask. I have a family out there. Yeah, I can say, hey, Your Honor, please grant me probation. I got this uncle and I got this uncle, and they out there doing big things, and I'm just doing nothing, and I just want to get my life back on track. It's probably not gonna happen. Only God knows. Maybe you would grant probation. I don't know. It's up to you. But at the same time, Your Honor, 130 months is a long time. And just like that officer said, okay, he testified that I brought that boy's stuff back. I told him I was coming back, and I brought it back. What didn't come out in the case, Your Honor, is that but Michael Coles made the report at 6 o'clock in the morning. That's when he made the first police report. Okay, 6 o'clock in the morning, Your Honor. I left him at 4 o'clock in the morning. Okay, it took him 2 hours to make a 15-minute walk to the police. Okay, he also testified to the detective, and this is facts in the case, and you can ask Chris. Okay, they said I'm getting loud. Okay, but he told the detective, Your Honor, that he watched me on his laptop. He watched his phone. Okay, he watched me to see where I was going. Your Honor, he was expecting me to bring my wife back to him so he can get his virginity broke. That was the whole purpose of him giving me the money, Your Honor. The purpose wasn't for me to intimidate, or it wasn't for me to torment him. I wasn't tormenting him. Okay, I wasn't. I'm gonna say I wasn't even bullying him. Now, when it comes to intimidation, I was intimidated. I was intimidating him. I was putting fear into him, Your Honor. But
You gotta lower your voice, man.
I did. You just told me.
Yeah, no, you didn't lower it.
I did lower it. Okay. Your Honor, this is all I ask. That you not sentence me to 130 months, okay, in prison. All right. I ask you to be fair. I ask you to look at the case. You know, look at the end result. I did bring his stuff back. He did have my wife's keys. Robbery is taking his stuff, and even though the jury found me guilty of it, robbery is taking his stuff. It's permanently depriving somebody of their stuff. It's robbing somebody. Okay, but I returned. One of the officers said, "Why did you just stay gone?" You know, I've had people say, "Well, why did you return?" I returned to bring him his stuff back that I told him I was gonna bring back.
We didn't tell him.
I brought my voice down. Your Honor, they're complaining about my voice, but I brought my voice down. Okay, I stopped. They want me to whisper. Can you hear me, Your Honor?
I can hear you just fine.
I'm sorry. They got another person in here, so I guess they're saying I'm getting too loud. But the only thing I ask you, Your Honor, is if I can't get probation. I mean, I can tell you like this, and I can tell Suzanne, and I can tell Chris, and I can tell you, if I was to get out, I wouldn't be back in here, man. Okay, when I do get out, whether it's 130 months, whether it's 8 years from now, and I got 14 kids. I'll be honest, I got a total of 14 kids out there. Um, and I'm looking at my oldest. My oldest just turned 16, May 15th. Okay. 8 years with good time. She's gonna be 24. Okay. I'm gonna miss her. I'm gonna miss her graduation. I'm gonna miss all my other kids' graduation. My youngest is 1, 2, 3, 4, and 5. Okay, but I got 13, 13, 13, 13, 14, 14, and all up. Okay, I'm gonna miss their graduation, and I'm just asking you to be light. You know, be like, if you was my father, I'd be like, Daddy, be light on my whooping. Okay, I know I did wrong, but I didn't do the just of what is making it be seen. I didn't run with his stuff and go take his car and ditch his car and set it on fire and throw his phone and break his phone. And that's what a robber would have did. I took this guy's stuff. I took his car. I took his phone. I'm about to set this car on fire. So they ain't got no evidence. I actually gave them the evidence, and the reason I recorded the evidence. And Ms. Valadez said, well, in the evidence, you can see he tormented the person. Your Honor, that's not true. In the evidence, you can see me and the guy talking, and I'm recording my wife, and I'm recording our conversation. And that was all actually recorded so he knew that I wouldn't tell the police on him, because that's originally how I went to him, and he said it in the police report. So, the original statement to him was, hey, if you don't help me get my wife back, I'm going to call the police on you. That's what the original statement was. And that's why I was recording. I wasn't recording to show I'm some big bad wolf and I can intimidate people and I can terrorize people. I was recording so he knew that I had evidence if he didn't help me that I could get him into trouble. He told the detective that. He said he was gonna call the police on me. And so, Your Honor, I'm just asking you to be light on the punishment that you're giving me. And I'm gonna be honest, people out on the streets already saying I'm getting. They already saying I got 11 years. Okay, they're already saying it, and it's not it ain't came from me. It's coming from my wife. He's telling people, and they got it going around, and I'm getting 11 years. So, I just ask you to see the case, and be light. That's it.
Thank you.
Sorry for taking so long.
Ms. Valdez, the defendant asked if you wanted to respond to anything after he was done. Do you have anything to add?
Sorry, Your Honor. No, nothing to add, Your Honor.
All
But
right.
I appreciate that.
Mr. Scott, do you or your client know any legal reason why I should not now proceed to sentencing?
No, Judge.
All right. Well, it never ceases to amaze me because I frankly have spent enough time around Mr. Dupree. I think he is more intelligent than most people that I see. And that probably includes most of the lawyers that are in front of me. But for some reason, he has an opinion that he can talk his way out of things, and he ends up making admissions and doing things such that he puts himself in a worse situation. And frankly, what I heard from him today during this whole thing was a lot of about minimizing what he did, about excusing what he did. But what I didn't really hear anything about was any kind of acknowledgement of what this did. Look, I think we all experienced Mr. Coles, and unfortunately, none of that is going to come across on the paper of the transcripts. I don't know if he suffers from any kind of developmental delay or anything like that, and I'm not considering that he did. But he certainly presented as a person who was ripe for exploitation by bad actors. And frankly, the difference in this case from a lot of cases is we have to listen to the victim talk about their feelings and what it was like to be in the presence of this person and during this going on. But everybody in that courtroom got to live it because Mr. Dupree videotaped it on this phone. And so there was an unusual ability in this case for us to experience the crime along with the victim. And frankly, it was disturbing. It was scary. The court certainly couldn't help but, while watching the video, feel sympathy for, not just empathy, but sympathy, because we were living it along with them, with him, the scariness of this. And for Mr. Dupree to say, yeah, I tried to intimidate him, but we were friends. We all watched the video and we saw the way Mr. Dupree conducted himself and his high level of agitation, his unpredictability, his whole demeanor, his whole attitude towards that was scary. I don't know how I could argue that robbery, which I think of as this, the difference between a robbery and an ag robbery. In a robbery, somebody comes up and demands your money. With an ag robbery, they come up and point a gun at you and demand a robbery. This is a robbery that took hours of this guy to live through, not moments of somebody coming up and shaking him down, but hours to go through this process of robbery. I believe that if anything, the harm in this case to Mr. Coles exceeds that of a normal robbery where somebody, you walk around the corner and somebody jumps out and scares you into turning over your wallet. This is an event that he lived for hours. And so I don't find that there's substantial and compelling reasons for a downward departure. I think that given the conviction, frankly, if you look at the difference between kidnapping and criminal restraint, it's all about the intent of restraining a person. Both of them talk about restraining the person. One is to commit a crime, one is just to do it. And that's a simplification. But frankly, a kidnapping would have left Mr. Dupree with practically a 20-year presumed sentence as a baseline. And, you know, I'm not sentencing him because of that. I'm not departing upward because of that, because that's the jury's verdict, what they found. And I think it was fairly so. But look, Mr. Dupree, part of, again, what he had to say today was, I don't prey on the weak. I think that the entire, watching that videotape during the course of that trial was Mr. Dupree preying on the weak. Look at his criminal history, what his convictions were for, what his person convictions were for. Aggravated indecent liberties. That's preying on the weak and the young. So I do think he does that. I think he presents a substantial danger to community. And I believe that the presumed sentence is a just sentence in this case. So therefore, I am going to sentence Mr. Dupree thusly for count one, that being the, count of aggravated robbery, I'm sorry, of robbery, not aggravated robbery. My PSI just disappeared on me. 1 second. From the amended pre-sentence investigation, for the first count, that being robbery, a severity level 3 person felony, a severity level 5 person felony, he will be sentenced to the presumed range of 130 months. You'll be eligible up to 15% good time credit from that time, and is granted jail time credit for all of that time he's been in jail. When he's released, he will be subject to a post-release supervision duration of 36 months. His request today for probation is considered and it is denied, as it is not appropriate in this case. As to count 2, the severity level 5 drug felony of possession of methamphetamine, he'll be sentenced to the standard range of 11 months, and also eligible for 15% good time credit, subject to 36 months of post-release supervision. That sentence is ordered to run concurrently with that in count 1. As to count 3, the criminal restraint, a severity level A person misdemeanor, he will be sentenced to 12 months in county jail. That count will also be ordered to run concurrently with count 1 and 2. For purposes, I'm talking about counts of conviction. The criminal restraint was actually the lesser included of count 1. The robbery was count 2, and the possession of methamphetamine was count 3. But all of those counts are run concurrently in this case. Probation is denied. Ms. Valdez, do you have, do we know how much jail time credit Mr. Dupree has?
Your Honor, I don't now. Like I said, I was going to prepare for what I thought was a Thursday hearing day, and I didn't get a chance to do that.
Judge, credit from
but I
July
can-
13th of last year.
Okay.
All right, I'll need you all to calculate that, and I will tell you that the defendant is granted credit for all of that time. Ms. Valdez, I know that most, if not all of the property was returned to the victim. Has he requested any restitution?
Your Honor, beyond the amount that was released to him, no.
Okay,
That was
All right.
that was returned to him.
all right. Mr. Dupree, you have 14 days from today to appeal anything about this sentence that you disagree with. You also have the right to seek expungement following a period of time after successful completion of supervision. As a convicted felon, it is prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically any knives that could be considered weapons. If you were to decide at some point in the future you needed to own or possess any kind of weapon like that, talk to a good lawyer like Mr. Scott prior to doing that to make sure that it wouldn't be a violation of your probation or reason for you to have new charges. This is a registration offense. 3 days following your release, you will need to report to your county of residence and register with the sheriff there as a convicted felon. In this case, let's see. Mr. Scott, if you have your bids fee, given the length of time Mr. Dupree is going to be spending incarcerated, I don't find that there's a reasonable plan for him to be able to pay any kind of court cost fees or reimbursement fees. You can simply submit those to me. I'm interested in this. I know that Mr. Dupree has previous Kansas felonies, but they look like they were from 2006. Were we doing DNA swabs at that time?
I think so, Judge.
Okay.
But most of the time the court will just, I've seen some judges waive them, but
Well,
sometimes it's,
I believe his DNA is already on file, so that they should not he should not pay that fee. If for some reason I find out that he's not had his DNA taken then I'm going to waive the fee anyway. As I said, Mr. Dupree will be spending significant period of time, and I don't see that there is a reasonable plan that he could pay all of these following this sentence. All right. Ms. Valdez, I will ask you first. Is there anything that you feel that I failed to cover in today's hearing?
Nothing, Your Honor, and I believe that I just need to submit a journal entry then. I mean, this is sort of out of the norm in doing it through
Right.
this platform. So then just for Mr. Scott to review and then for the court signature.
Yeah, we've been doing it where the prosecutor's been preparing that, sending it to defense counsel. They sign it, or else they send an email that says you can put my electronic signature on that, and then e-filing it for my signature. I have an order of commitment and a cost sheet that I will fill out and send to probation department, who handles the transfer there to the Department of Corrections. Mr. Scott, if you would submit 3 things to me. A journal entry on your motion for new trial. Maybe this is 4 things. A motion to withdraw and have the appellate defender appointed. A notice of appeal, if that's what you and Mr. Dupree decide, and your voucher. Other than that, Mr. Scott, is there anything that you feel that I failed to cover today?
Judge, this is just for more bookkeeping purposes, since all the counts were ordered to run concurrent. But the court did say on the possession of methamphetamine that is 15% good time credit with 36 months of post release. It's actually, and that is what it says in the PSI. That would actually be on that level 5 drug felony. That would be 20% good time credit and 12 months of post release.
I understand, but the controlling sentence is what you use to calculate the percent credit and all of that, unless they are run consecutively. But since they're concurrently, the controlling sentence determines that, in my experience.
Thank you.
All right.
Was you gonna give me a date? I thought.
A date for what, Mr. Dupree?
Tell them to add up like the good time I already got or whatnot.
They are going to get, they're going to get together. They're going to figure out what day you ended up in jail and all of the jail time credit that will appear in your journal entry.
Okay.
When it comes time to calculate your good time, the Department of Corrections does that. The courts do not. So that will happen when you arrive.
All right. All
All
right.
right.
Thank you.
Anything else for our record today? We are adjourned. Thank you, everyone.